Hi, everyone. My name is Rebecca Gutterman, and I work in the Disability Rights section of the Civil Rights Division at the U.S. Department of Justice. We've created this webinar to help members of the public better understand a rule on web and mobile app accessibility that the department published under Title II of the Americans with Disabilities Act in April 2024. The rule applies to public entities, which we'll also refer to as state and local government. For too long, too many people with disabilities have been excluded from important state and local government programs because their state and local government's websites and mobile apps are not accessible. This rule is really important because it will help make sure that everyone can access their state and local government's websites and mobile apps, regardless of whether they have a disability. Let's go over the goals for this webinar. First, we want to help you get generally familiar with what the rule requires. Think of this as your introductory course. If you work for or with a state or local government, this webinar will help you learn about what the rule requires you to do. If you are a person with a disability or a disability rights organization, this webinar will help you learn more about your or your client's rights under the rule. As I mentioned, this presentation won't be comprehensive, and we know that you will likely continue to have questions after the presentation is done. So our second goal is to give you a toolkit that you can consult when you have questions in the future. Those resources are linked in the video description, and we'll go over them at the end of the presentation. I also want to clarify what this webinar will not include. This will not be an in-depth presentation on the ins and outs of the technical standard that the rule adopts, which, as I'll get into later, is called the Web Content Accessibility Guidelines version 2.1. Instead, this will be a presentation on the legal requirements for which content does or does not have to follow that technical standard. The World Wide Web Consortium, which is the group that publishes the technical standard, has other resources that may help you better understand that standard. I'll now provide a quick roadmap for our presentation. First, we'll talk about why web accessibility matters. Then we'll provide some background on the ADA statute and regulation. Then we'll go over who has obligations under the rule, what those obligations are, and when those obligations go into effect. Then we'll talk about some exceptions to the obligations under the rule and some other situations when state and local governments might have some flexibility in terms of how they meet their obligations. And then finally, as I mentioned, we will provide some additional resources to consult, and we'll talk about what this rule might mean for you. Throughout the webinar, we'll pause for informal knowledge checks. These are just brief quiz questions for you to think about so that you can make sure you are understanding the presentation. This webinar will run for a little over an hour. We think it is a helpful presentation with lots of useful information, but if you don't have an hour to spend watching a webinar, there are some shorter handouts that you can review on ada.gov that will give you basic information about the rule. We've included links to these documents in the video description. So without further ado, let's dive into the material. Let's first take some time to talk about why web accessibility is so important. I want you to take a moment and think about the times in the past that you have visited your state or local government's website or mobile app. Perhaps you used an app to pay for parking. Maybe you looked at a school calendar on the website for your child's public school. Maybe your child logged on to a website to download their public school homework assignment. Maybe you filled out a form to register to vote online. If you went to a public hospital or healthcare system, maybe you used an online portal to sign in for appointments, communicate with your provider, or access test results. Maybe you made a maintenance request, like a request to fill a pothole. Maybe you renewed an ID card. Maybe you reserved a space in a public park. These examples are just the tip of the iceberg. I'm sure you all can think of many other examples of government services you've accessed online. And if you work for or with a state or local government, I'm sure you can think about many other services that your state or local government offers online. Now, think about how impactful and disruptive it would be if those websites and mobile apps were not designed in a way that you could use. You might still be able to use the website or mobile app, but it might take you twice as long to complete the task you're trying to complete. You might have to get somebody else to help you every time you want to use a website or mobile app, which could be a real invasion of privacy, especially if you're trying to do something that involves sensitive personal information. Or worst of all, you might not be able to complete the task at all. If you're a person with a disability that affects your ability to use the web or mobile app, this is all too familiar for you. Unfortunately, it's all too common for there to be accessibility issues on state and local government websites and apps, which has meant that some people with disabilities have been excluded from these kinds of government services for far too long. To help illustrate this problem, I'm going to play two audio clips for you. One major accessibility issue is that we see websites, mobile apps, and documents aren't designed for a screen reader to accurately read them. This can make it really hard or impossible for people with visual disabilities to access the content. Let's first listen to an audio clip demonstrating what it sounds like when a screen reader opens and reads a PDF form that was not designed accessibly. In this audio clip, you'll hear the screen reader announce what it thinks is in the form as the user moves from one section of the document to the next. As you're listening, try to decide if you would know what to do with this form based on what the screen reader is saying. What the screen reader is saying will also be included in the caption.
Edit, type in text. Edit, type in text. City, underline, state, underline, zip code, underline, edit, type in text. Edit, type in text. Edit, type in text.
As the screen reader went through this document, it said edit, type in text a number of times, but it's not clear what text should be typed in. The screen reader also said city, state, and zip code, along with a bunch of odd colons and underlines. So based on what the screen reader announced, you might guess that this part of the form is for entering your address, but it would be impossible to know exactly where and when to type each part of your address. As it's currently formatted, the PDF is basically useless to someone who cannot see the form and uses a screen reader. This slide shows the form the screen reader was actually trying to read through. There are fields for first name, last name, address, city, state, and zip code. Each field includes a text label and an associated box to type in the information. Let's listen to an audio clip next that shows what it sounds like when the form is designed accessibly so that the screen reader can accurately read it.
First name, edit, type in text. Last name, edit, type in text. Address, edit, type in text. City, edit, type in text. State, edit, type in text. Zip code, edit, type in text.
When the form is designed accessibly, it's immediately clear what each section of the form is for. For example, a user knows to type their first name. After hearing first name, edit, type in text. Someone who could not see this form would still be able to fill it out using a screen reader. This is just one example of the type of problem that the department's new rule is designed to help solve. There are also lots of other kinds of web accessibility issues that can affect people with lots of other kinds of disabilities. As we noted earlier, our hope is that our rule will make sure that everyone can access their state or local government's websites and mobile apps, regardless of whether they have a disability. I'll now give some brief background on the ADA statute and regulation. The ADA, for anyone who is not already aware, is a federal civil rights law that prohibits discrimination against people with disabilities in everyday activities. The ADA is broken up into 5 different sections or titles. The rule is under Title II, which covers requirements for public entities, including state and local governments. The ADA regulations have always made clear that state and local governments have to make sure their services, programs, and activities, which we'll call services for short, are accessible to people with disabilities. The department has consistently said that these requirements apply to all services that a state or local government offers, including those offered via the web and mobile apps. But until now, the department never issued a regulation specifying what technical requirements those state and local governments have to meet to satisfy their obligations under Title II. For years, people have been asking the department to issue a rule on this topic. And that's part of what makes this rule so important. It establishes specific requirements, including adopting a specific technical standard that make clear for public entities what they have to do to make sure that their web content and mobile apps comply with the ADA. So with that, let's dig into the requirements of the rule. Let's first go over who has obligations under this rule. In other words, who is required to take the actions that the rule requires. As I mentioned earlier, the rule applies to public entities, as defined under Title II of the ADA. Public entities include state and local governments and any agencies or departments within those governments. Examples of public entities include public schools and universities, state and local law enforcement and courts, public hospitals and healthcare services, parks and recreation programs, libraries, state benefits programs, and many more. So let's talk about the kinds of content that the rule applies to. The rule applies to web content and mobile apps that a state or local government provides or makes available, whether directly or through contractual, licensing, or other arrangements. That was a lot of legalese, so let's break down exactly what that means. The rule includes a technical definition of web content that's based on the definition that's in the technical standard, we'll discuss shortly, which you can check out in the rule itself. But in simple terms, web content means basically anything that's posted on the web, including web pages, images, sounds, videos, PDFs, and other documents. Basically, think about functions that a city or county or a state might offer on its website, signing up for weather emergency alerts, filing a police report, paying bills, applying for a permit, among many others. All of those functions would generally have to comply with the technical standard in this rule. The rule applies to both content that is on the state or local government's own website, as well as the state or local government's web content that is posted elsewhere on the web. This includes, for example, a public entity's social media posts. The rule also applies to mobile apps, which, as you probably know, are software applications that are downloaded and designed to run on mobile devices. Think about mobile apps that you might have used to access a public entity's services in the past, perhaps an app to pay for parking or an app to submit a maintenance request. A public entity would generally need to make sure that the app it uses for those purposes meet the technical standard. So as I mentioned, the rule applies to web content and mobile apps that state and local governments provide or make available directly or through contractual licensing or other arrangements. So what does that mean? It means that the technical standard applies not only to web content and mobile apps that a state or local government creates or posts itself, but also to web content and mobile apps that are created or posted by someone else on behalf of that government. For example, if a city government hires a contractor to build the government's website, that government generally has to meet the technical standard. Also, if a city government uses a mobile app created by a private company to offer services to the public, the city generally has to make sure it uses an app that complies with the technical standard. This is the same as the existing rule under Title II, just explained in the context of web content and mobile apps. Both before and after this rule, state and local governments cannot avoid complying with the ADA by hiring someone else to do the work for them. So we'll now have our first knowledge check. These knowledge checks are just to help you check your understanding. After I read each question, I'll pause for a moment so you can think about the answer to yourself, and then I'll provide the answer. So here's the first knowledge check. Which of these are web content that would generally need to meet the technical standard in the rule? A PDF flyer showing recycling pickup dates on a public sanitation department's website. B, a video posted by a town on the town's official social media page. C, a website to pay county property taxes online. D, a city parks and recreation department's online system for reserving park shelters. Or E, all of the above. Take a few seconds to think about this for yourself. So the answer is E, all of the above. Each of the answers that I just read are examples of web content as the rule defines it. And because each of these are provided or made available by a state or local government, they generally have to meet the accessibility standard in the rule. As we'll discuss later, there are specific times where exceptions might apply, but generally speaking, each of these represents web content that has to be accessible. So I've talked about the type of content that has to comply with the rule and which entities have to comply with the rule. Now let's talk a little bit more about what standard those entities will actually have to make sure their content meets. Under the final rule, public entities will need to make sure that their web content and mobile apps comply with the Web Content Accessibility Guideline, also called WCAG, version 2.1, level AA. These guidelines were developed by the international organization called the World Wide Web Consortium, also known as W3C. So WCAG is a bit like the ADA standards for accessible design in the physical access space. Just like the ADA standards for accessible design specify what makes a building accessible, like the width of a door, as shown in the diagram here on this slide, the technical standard we are adopting in this space will let public entities know what they need to do to make their web content and mobile apps accessible. WCAG 2.1 is broken down into success criteria, which describes specifically what has to be done to conform to the technical standard. A success criterion is like a box that a public entity has to check to make sure their content is accessible. Success criteria are classified as level A, level AA, or level AAA. This rule adopts level AA, which includes all of the core level A criteria as well as the AA criteria. As we said at the beginning, this isn't a presentation about the ins and outs of WCAG, but I'll just give two examples of what WCAG requires to help you get a feel for the standard. One example is that WCAG 2.1 requires alternative text for visual images. This helps, for example, people who cannot see pictures because assistive technology can present the information in an alternative way, such as a screen reader that reads the alternative text aloud. On this slide, you can see the image of DOJ's seal with one possible text alternative, U.S. Department of Justice seal. Another example is that WCAG 2.1 has requirements for captioning, which can help, for example, people who are deaf access certain content. On this slide, you can see a screenshot from an online video with captions displayed on the screen. The captions appear at the bottom of the video and identify what the video's narrator is saying verbally. There are lots of useful resources published on the W3C's website that can help you get better acquainted with WCAG 2.1. So we encourage you to consult those to learn more about the standard. If you're not sure where to start, the Small Entity Compliance Guide for this rule, which you can find on ada.gov, includes a suggestion. So now that we've talked about the technical standard under the rule, let's talk about when public entities need to make sure that their content meets that technical standard. The date on which public entities will need to comply with the technical standard depends on the size of the entity. As shown on the slide here, public entities that have populations of fewer than 50,000 people will have to comply with the rule by April 26th, 2027. The same goes for special district governments, a less common type of government that I won't get into here, but that is discussed further in the rule. And then public entities that have populations of 50,000 or more will have to comply with the rule by April 24th, 2026. Smaller entities have an extra year to comply because we understand from public feedback that those entities may have particular budget challenges. You might be wondering how an entity can figure out what its population is for the purpose of determining when it has to start complying with the rule. There is a whole section of the rule that lays this out, so you can look at that more closely if you are trying to figure out which compliance state would apply to a particular state or local government. The basic principle is that state and local governments' populations, for purposes of this rule, are based on their populations as calculated by the United States Census Bureau. And if public entities don't have populations calculated by the Census Bureau, like if they are a library or a police department or a university, their population is determined by the population of the state or local government that the entity is affiliated with. One final point about the compliance states before we move to a knowledge check. As I mentioned previously, state and local governments are already required to make sure that their services offered via the web and mobile apps are accessible. More specifically, state and local governments have to make reasonable modifications, ensure effective communication, and provide equal opportunity to people with disabilities to participate in or benefit from government services offered online and through mobile apps. We'll refer to these public entities' existing obligations. Public entities still have to comply with these existing obligations even before the compliance dates for this rule arrive. There's a lot more information about all of these existing obligations on ada.gov in case you are interested in a deeper dive on any of those topics. Now let's get into our next knowledge check. A county community college has 8,000 students, but it is part of a county that has a population of 1 million people. Does the community college have to comply with the rule A, by April 2026, or B, by April 2027? Take a few seconds to think about this for yourself. The answer is A. The community college has to comply by April 2026. For purposes of this rule, the community college's population is determined by looking at the population of the county that the college is a part of. In this instance, the relevant county has a population of 1 million. Because 1 million is over the 50,000 people threshold, the college has to comply within 2 years. The number of students enrolled at the college is not relevant for purposes of calculating population under this rule. Let's do just one more knowledge check related to the compliance date. So true or false? A county has a population of 5 million. The county doesn't need to think about web accessibility until April 2026. True or false? Take a few seconds to think about this for yourself. So the answer is B. This is false. First, while state and local governments are not required to comply with the specific provisions of the rule until the compliance date specified in the rule, we again want to emphasize that state and local governments have what we refer to as existing obligations under the ADA. These requirements still apply before the rule's start date. And second, it can take time to make web content and mobile apps accessible. Public entities should think ahead to make sure they are fully in compliance with the technical standard by the time the compliance date rolls around. And now I'll turn it over to my colleague, Badr Tareen, who also works in the Disability Rights section of the Civil Rights Division at the U.S. Department of Justice.
As we've mentioned, state and local governments' web content and mobile apps will generally need to meet this technical standard in the rule, which again is WCAG 2.1 Level AA. But the rule also says that there are situations when some kinds of content would not need to meet the technical standard at the outset. As shorthand, we refer to these situations as exceptions to the rule. In particular, there are 5 limited exceptions in the final rule. These exceptions are included so that state and local governments have flexibility to prioritize making the most important content, like current or commonly used information, accessible to people with disabilities quickly. And before discussing each of the exceptions, we want to make clear that what the exceptions do not change. Even if certain content falls within an exception and therefore doesn't need to comply with WCAG 2.1 at the outset, public entities still need to comply with their other existing obligations under the ADA. This means that even if certain content is subject to an exception, public entities still need to make sure that their services offered via the web and mobile apps are accessible to people with disabilities on a case-by-case basis. We'll now turn to a more specific discussion of the exceptions in the rule. The first exception is for archived web content. The definition of archived web content has 4 elements. In order to fall into the exception, the content must, 1, have been created before the date a public entity must comply with this rule, or reproduce paper documents or the contents of other physical media, like audio tapes, film negatives, and CD-ROMs, for example, that are created before a public entity must comply with this rule. And 2, it must be kept only for reference, research, or record keeping. And 3, it must be kept in a special area for archived content, like an archive section on a public entity's website. And 4, it must have not been changed since it was archived. Again, the content has to meet all of these elements to qualify for this exception. Here's one example of content that would qualify for this exception: an unedited water quality report from 1998 that a state has stored only for research purposes in an archive section of its website. So let's go through these 4 elements. First, it was created in 1998, which is before any public entity had to comply with this rule. Second, it's kept only for reference, research, or record keeping. Third, it's in a section of the website clearly labeled as an archive. And fourth, it has not been edited since it was archived. So the report would qualify for the exception. In contrast, an example of content that would not fall within the exception is a PDF document that includes up-to-date instructions for scheduling an event in a county park. The PDF provides current information about using the park, so the PDF is not only kept for reference, research, or record keeping, and does not qualify for the exception. Let's turn to our next knowledge check. A county posts a manual on its website that explains how people can request county services like filling in potholes and planting trees. The manual is posted in an archive section of the website. The manual was originally created in 2000, but it is periodically updated after it is posted. Does the manual fall within the archived web content exception? A, yes, B, no. Take a few seconds to think about this for yourself. The answer is B. The manual would not fall within the archive web content exception. The manual is used to explain how to request certain current county services, so it is used for purposes other than reference, research, or record keeping. And the manual is periodically updated, which means it has been changed since it was archived. So even though the county put it in an archive section, it doesn't qualify for the exception. The second exception is for pre-existing conventional electronic documents. There are 3 elements that a document has to meet to qualify for this exception. 1, it must be a conventional electronic document. Conventional electronic documents, or CEDs, is a new term that we defined in the rule. CEDs are limited to PDFs, word processor files, presentation files, and spreadsheet files. Other file types do not qualify as CEDs. 2, it must be pre-existing. CEDs are covered by the exception if a public entity posted them before the date it has to comply with the rule, meaning before April 2026 or April 2027, depending on the size of the government. 3, it's not currently used to apply for, gain access to, or participate in the public entity services. The exception is meant to cover old content that isn't used anymore. So if content is still used to access the public entity services, it doesn't qualify for the exception. One example of a document that would qualify for this exception is a PDF flyer for a Veterans Day parade posted on a town's website in 2018. Let's go through the 3 elements. This document is 1, a PDF, so one of the covered file types. 2, available on the website since 2018, before anyone had to comply with the rule. And 3, is for Veterans Day parade that already happened. So it likely is not currently being used to apply for, access, or participate in the town's services, programs, or activities. So this flyer would be a pre-existing conventional electronic document, and the town would not have to make the PDF meet WCAG 2.1. In contrast, think about a PDF version of a state's business license application that it posted this year. And for the next 10 years, that is still the version members of the public must use to apply for a business license. Let's go through the three elements again. 1, this is the PDF. 2, it was put on the website this year before anyone has to comply with the rule. But 3, it would not qualify for the exception because in 2026 or 2027, it will still be the version of the application that members of the public currently use to apply for that business license. Let's do our next knowledge check. In 2030, a city updates a Microsoft Word document that was first posted on its website in 2020 to include the city's new contact information. Does the document qualify for the exception in 2030? A, yes. B, no. Take a moment to think about that to yourself. The answer is B. The document does not qualify for the exception because it is not pre-existing. It was changed after the date the city was required to comply with the rule when the address was updated. The third exception for content posted by the third exception is for content posted by a third party. There are two elements that must be met to qualify for the exception. First, the content must be posted by a third party. And second, the third party cannot be posting due to contractual, licensing, or other arrangements with the public entity. In this context, third parties don't include vendors or others acting on behalf of the public entity. By third party, we mean people who are truly not acting for the public entity. The exception would apply, for example, to documents filed by a third-party lawyer on a state court's website. This is because the documents are posted by the lawyer, who is a third party, and the lawyer is not posting due to contractual, licensing, or other arrangements with the state court. The exception does not apply to the tools or platforms that a public entity provides on its website or mobile app, even if those tools or platforms are used by third parties. So in the example I just mentioned, if the state court has a system on which people can file documents, the system itself has to meet the technical standard, even if materials filed by third parties in that system don't need to meet the technical standard. That's because the system itself is not posted by third parties. Let's do our next knowledge check. True or false? A public entity uses a private company to design, manage, and update its website. The content the private company posts for the university is covered by the exception for content posted by third parties. Take a moment to think about that to yourself. The answer is false. In this case, the company is posting due to contractual, licensing, or other arrangements with the public university. The public university cannot avoid its obligations under this rule by having a private company post its content. The content the company posts for the government would therefore not fall under the exception, and it would generally need to meet WCAG 2.1 level AA. The fourth exception to the technical standard is for certain individualized password-protected documents. There are three elements that a document would have to meet to qualify for this exception. 1, the document must be a conventional electronic document, which, as we described earlier, are word processing files, presentation files, PDFs, or spreadsheets. And 2, the document must be about a specific person, property, or account. And 3, the document must be password protected or otherwise secured. The exception would apply, for example, to a PDF version of a water bill for a person's home that is available in that person's secure account on a city's website because the PDF is a conventional electronic document, it's about a specific person's account, and it's on a password-protected website. The PDF would therefore generally not need to comply with the technical standard. Of course, again, public entities still have other obligations under the ADA outside of this rule. So even if a particular document, like the water bill for this example, falls under this exception to the technical standard, if a person with a disability needs access to the information in that document, the public entity would still generally have to provide the information in a format that is accessible to that person. So even though the individual PDF water bill would fall within this exception, the portal where the water bill is posted does not fall under the exception and still has to comply with the technical standard because the portal is, one, not a conventional electronic document, and two, not about a specific person, property, or account. So our next knowledge check, true or false? A water company posts a PDF on a password-protected website about an upcoming rate increase for all customers. This PDF document is covered by the exception. Take a moment to think about that to yourself. The answer is false. The exception would not apply because the document is not about one customer's account, but is rather applicable to all customers. Let's get into the fifth and final exception, which is for pre-existing social media posts. As we mentioned previously, public entities generally need to make their social media posts comply with the technical standard. The public entity isn't responsible for making sure that the whole social media platform is accessible, but the entity generally has to make sure that when it posts on social media, its own posts are accessible. But there is an exception for social media posts that were posted before the date a state or local government is required to comply with this rule. So, for a public entity or a special district government, this exception would apply to social media posts that were posted before April 2027. For a large public entity, this exception would apply to social media posts that were posted before April 2026. If, for example, a city had posted on a social media in 2010 about winter parking restrictions, that would count as pre-existing. That is because it was posted before anyone had to comply with this rule. So the city would not have to go back and make that post meet the technical standard. In comparison, if a public entity made a social media post in 2030 about winter parking restrictions, that post would not qualify for the exception. This is because it was made after the date all public entities have to comply with the rule. So let's do our next knowledge check. A city makes a social media post in October 2026, asking residents to send in pictures of their pets in Halloween costumes. Is that post covered by the exception for pre-existing social media posts? A, yes. B, no. C, it depends. Take a moment to think about that to yourself. The answer is C, it depends. This exception applies to social media posts before the compliance date, which depends on population size. So the answer to the question varies depending on the size of the entity. A small city, less than 50,000 people, has to comply with the rules starting April 2027. A post in October 2026 is before that date. The post is therefore pre-existing and so would not have to meet WCAG 2.1 under this rule. A large city, 50,000 people or more, has to comply with the rules starting April 2026. So a post in October 2026 is after that date. The post would therefore not be pre-existing and so would have to meet WCAG 2.1. With that, I'll turn it back to my colleague, Rebecca.
So we'll now talk about some of the other miscellaneous provisions in the rule. One part of the final rule discusses what's called conforming alternate version. Sometimes a public entity tries to have two versions of the same content, one version that is not accessible and another version that is accessible and provides all the same information and features. The second version is called a conforming alternate version. Conforming alternate versions are only allowed in rare situations under the rule. There has to be a technical limitation or a legal limitation that prevents a public entity from making content directly accessible. If you are already familiar with WCAG, you might notice that this is a little different. Under WCAG, conforming alternate versions are always allowed, but our rule allows them only when there is a technical or legal limitation that prevents the content from being made directly accessible. The rule explains more about why we took this approach. In short, we are concerned that the use of conforming alternate versions could result in segregated access for people with disabilities and would be inconsistent with how the ADA's core principles of inclusion and integration have historically been interpreted. Whether there is a technical or legal limitation really depends on the facts, but we wanted to provide a few examples to help illustrate when there might or might not be a technical or legal limitation. So here's one example that might qualify as a technical limitation. If a state publishes web content that uses an immersive virtual reality environment and it is not yet possible to make accessible. And then here are two examples that would not qualify. If a town's web developer lacks the knowledge or training needed to make the town's website accessible, that is not a technical limitation. Similarly, if a city's general counsel failed to approve contracts for a web developer with accessibility experience, that is not a legal limitation. Let's go through a knowledge check. A town decides for purely aesthetic reasons that it would rather not make any changes to make its main website comply with WCAG 2.1. Instead, the town would like to make a separate version of its website that is accessible. Does the rule allow the town to provide a conforming alternate version under these circumstances? Yes or no? Take a moment to think about that to yourself. The answer is no. Wanting to keep your content the same for purely aesthetic reasons would not qualify as a technical limitation under the rule. The rule also includes a provision on equivalent facilitation. Under this provision, a public entity may use designs, methods, or techniques as alternatives to WCAG 2.1 Level AA, provided that the alternative designs, methods, or techniques result in substantially equivalent or greater accessibility and usability of the web content or mobile app. So, for example, if an entity wanted to use a future version of WCAG, like WCAG 3.0, that provides an even higher level of accessibility, that would be allowed. Let's do a knowledge check. A public university complies with WCAG 2.0, which is an earlier version of WCAG with 12 fewer success criteria than WCAG 2.1. Does this count as equivalent facilitation under the rule? Yes or no? Take a moment to think about that for yourself. The answer is no. This does not count as equivalent facilitation. WCAG 2.1 has 12 more success criteria than WCAG 2.0, which means that WCAG 2.1 sets a higher standard for accessibility. WCAG 2.0 does not provide substantially equivalent or greater accessibility and usability than WCAG 2.1. The rule also says that public entities don't have to take actions that would result in a fundamental alteration of a service, program, or activity, or an undue burden. If you are familiar with the ADA, you may recognize these terms. This part of the rule is modeled on the undue burden and fundamental alteration limitations in the existing Title II regulation. Determining what a fundamental alteration or undue burden is differs from entity to entity and sometimes from one year to the next. There's a lot of information on ada.gov about these limitations if you're interested in learning more. In general, it will not be a fundamental alteration for a state or local government to make its web content and mobile apps accessible. And even if complying with some parts of WCAG 2.1 for some content would lead to an undue burden or fundamental alteration, an entity is still not totally off the hook. The entity still has to do everything that is not an undue burden or fundamental alteration to make sure that people have as much access as possible. Let's do another knowledge check. So a web developer at a public hospital reviews this rule and thinks it will probably take a lot of work to comply. Does the hospital automatically qualify for the undue burden limitation? Yes or no? Take a moment to think about it for yourself. The answer is no. This hospital does not automatically qualify for the undue burden limitation. Whether a particular action counts as an undue burden is very fact-specific and depends on the entity's particular situation. A public entity has the burden of proving that compliance would result in an undue burden, and there are specific things a public entity has to do if they want to claim something would be an undue burden. You can find more details about this limitation in the rule. The final rule also says that in limited circumstances, a public entity can be considered in compliance with the rule, even though the public entity's web content or mobile app does not perfectly conform with WCAG 2.1 level AA, if the public entity can demonstrate that noncompliance has a minimal impact on access. This means that there are some situations where part of a public entity's web content or mobile app does not meet WCAG 2.1 level AA, but the difference is so small that it would not change a person with a disability's access to the content or app. In those limited situations, a state or local government can be considered in compliance with the rule, even though they are technically not meeting all the parts of WCAG 2.1 level AA. State and local governments should not use this part of the rule to avoid trying to meet WCAG 2.1 level AA in the first place. Instead, this part of the rule provides one way a government can show it meets the rule if someone finds a technical violation of WCAG on the government's web content or mobile app. To use this part of the rule, a state or local government has to prove that the deviation from WCAG 2.1 level AA has a minimal impact on access. And the rule explains what it means for a deviation from WCAG 2.1 to have a minimal impact on access. This means two things. First, that people with disabilities can still do the same things as people without disabilities using the web content and mobile apps, like access the same information or conduct the same transaction, and much more. And two, people with disabilities can still do these things in the same way with substantially equivalent timeliness, privacy, independence, and ease of use. So let's get into some examples. First, say that someone reports to a county government that its website violated one of the WCAG success criteria, which requires the spacing between words to be 0.16 times the font size. In response, the county shows that the spacing is only 0.15 times the font size instead of 0.16. The county also shows that this difference in spacing is so small that people with vision disabilities can still read the information on that webpage just as easily. The county would not be in violation of the rule. Let's talk about another example. Imagine that someone has a manual dexterity disability and is trying to renew their professional license on a state's website. They come across a part of the online renewal form that requires dragging and dropping a file with no other way to upload the file, which is in violation of one of the WCAG success criteria. They had to try multiple times to drag and drop the file because of their disability. They were eventually able to upload the file and renew the license, but it took twice as long as it did for a coworker without that disability. Even though they were eventually able to renew their license online, the state still violated the rule. Let's do one final knowledge check. A person who is blind is trying to fill out a form on a public entity's website. The form is missing labels for a screen reader to announce in violation of WCAG 2.1 Level AA. Because of this, the person cannot complete the form on their own. The person calls the public entity, and after the person waits for an hour on hold, an employee at the public entity reads the form aloud to the person. Because of this phone call, the person is ultimately able to submit the form. Is the public entity in compliance with the rule? Yes or no? Take a moment to think about that for yourself. The answer is no. The public entity is not in compliance with the rule. This provision is meant to address situations where there is a violation of WCAG 2.1 that has only a minimal impact on access. This example involved a violation that had a major impact on access. The person had to ask for help with the form because of the WCAG violation. They had to complete the form over the phone, even though a person without a disability could have completed the form by themselves online. Even though the person was ultimately able to complete the form by calling someone for help, they were not able to complete the form with the same level of timeliness, privacy, independence, or ease of use. Therefore, the public entity in this situation could not use this provision to claim they were in compliance with the rule. I'll now turn it back to Butler to finish us out.
We just threw a lot of information at you, and we don't expect that you'll remember every last detail from this presentation. Our hope is that your exploration of this rule will continue after this webinar, and we want to remind you that there are resources if you have questions in the future. We have a fact sheet that gives an overview of the requirements of the rule. We also have a small entity compliance guide, which is geared specifically towards people who work for or with state or local governments, and provides additional tips for how those governments might begin their efforts to comply with the rule. We also have a resource that contains suggested action steps that ADA coordinators and others working with state and local governments might want to take as they prepare to comply with the rule. And there are lots of other resources available on ada.gov, including the full rule. The department also operates an ADA information line that members of the public can call to ask any questions they have about the rule. All calls to the info line are confidential. The information line can be reached at 800-514-0301 for voice and 1-833-610-1264 for TTY. The hours for the information line can be found on ada.gov. Now let's talk a bit about what this rule might mean for you. If you work for a state or local government, then it's a good idea to start thinking about how your government is going to come into compliance with this rule over the next 2 or 3 years, depending on your entity's size. Creating and maintaining accessible web content in mobile apps takes planning. Some practices that you can use to help plan for success include creating policies on how you will make sure that your web content in mobile apps are accessible, creating processes for people to make accessibility requests and report accessibility issues, and training your staff appropriate to their specific roles and duties. Starting these practices well before the date that you have to start complying with the rule can help ensure the process goes as smoothly as possible. If you are a person who has rights under the Title II rule, we hope this presentation has been helpful in giving you an overview of your rights. Starting in April 2026 or 2027, you can expect that the web content and mobile apps of state and local governments should meet the requirements in the rule. But even before those dates, state and local governments still have to ensure the accessibility of services offered online and through mobile apps. I'll now read you a legal disclaimer about this presentation, which basically says that this presentation does not create any new requirements and instead just explains requirements that already exist under the law. The contents of this presentation do not have the force and effect of law and are not meant to bind the public in any way. This presentation is intended only to provide clarity to the public regarding existing requirements under the law or the department's policies. Thank you so much for attending this webinar. We hope it was informative.